Good afternoon. I'm Emily Iannucci, and I'm an attorney in the Garden City office of Schoeneck King. I'm a member here in Garden City, and I'm going to speak to you briefly about Section 201I of the labor law, which generally prohibits employers from requiring employees or job applicants to disclose their login information for personal accounts, including social media accounts. Now, the law applies to almost all employers in New York State, except for law enforcement agencies, fire departments, and departments of corrections or community services. Under Section 201I of the labor law, employers cannot require employees or applicants to disclose their username, password, or any other login information which would allow the employer to access the employee or applicant's personal accounts. In addition, employers cannot require any employees or applicants to access their own personal accounts in the employer's presence. Third, employers cannot require employees or applicants to reproduce or copy any content such as photos or videos or comments from their personal accounts and produce those to the employer. And last but not least, employers cannot retaliate against any employees who refuse to disclose their login information to the employer. So what can an employer do? First, employers can still require employees to disclose login information for their company accounts. If for whatever reason the employer needs to access an employee's company account, the employer is permitted to do so. Second, employers can require employees to produce login information for business-related accounts. However, under such circumstances, the employee should have been given prior notice that the employee does not have any right to privacy in those accounts. Third, employers can access an electronic device that was provided to the employee, which was paid for in whole or in part by the employer. However, under such circumstances, the employee must have agreed to allow the employer access to the electronic device in exchange for the employer paying for the device in whole or in part. And even under those circumstances, the employer cannot access an employee's personal accounts, which are on that electronic device. Fourth, employers can still restrict employees' access to certain websites that they do not want employees accessing while at work or during working time. And fifth, employers can still comply with court orders which would require them to produce such information. And last but not least, employers can still access employees' public social media accounts. And if an employee produces information about another employee's social media activity voluntarily, employers can use information that one of its employees voluntarily produced to the employer. Now, that's a summary of what employers can and cannot do. For more information about this topic, please contact your bond attorney, and we would be happy to assist you. Thank you so much.